Madison invited me to come speak, and I have to say, I was really honored when he did, because I know the caliber of speakers that the Jackson Center has brought in at some of their past events. When they were getting ready to publicize this event, Deb at the Jackson Center emailed me and asked me if I had a bio that they could use for their publicity materials. And I don't know about you, but that's not something I had. So I asked them if they could send me a sample from one of their past speakers. So she sends me a bio, and I open it up, and I show it to my wife, and she just laughs. And it's this 2-page long biography of the general counsel of a multi-billion-dollar company, Pepsi, maybe you've heard of it, who had previously served as the Deputy Attorney General of the United States. So this is my sample of what this thing. Anyway, so needless to say, I was a little intimidated. A little closer to home, my boss before the chief, Judge Jeffrey Sutton, gave this same talk 6 years ago. And after the talk, I was in my first year of law school, so I wasn't here, but after the talk, my father walks up to him and sticks out his hand and says, "I'm David Snyder. My son is Benjamin Snyder. He's a first-year law student at Harvard Law School. Look out for his application." And so my dad to this day maintains that is how I got my first job as a lawyer. And then last, but certainly not least, my last boss, the chief, spoke, as Jim was saying, at the Jackson Center last year. And I continue to have my suspicions that the way I ended up here is that Greg reached out to me to invite the chief to come speak. I accepted and agreed to come speak, and he never had the heart to tell me that I wasn't the one he meant to invite. So I'm here, so I'll try to make the best of it. Before I get into talking about the process of clerking, let me just sort of make sure we're all on the same page about the court. This will be very familiar to most of you, so I'll try to be quick. But the first thing to know about the court is that it's an appellate court, which means, with only a few exceptions that we don't need to worry about, it's always reviewing the decisions of other courts rather than deciding things for itself in the first instance. There's no Matlock testimony, there's no jury, there's no fact-finding. It's just 9 justices deciding tricky legal questions. The next thing to put on the table is that the court has control of its own docket, which means it gets to decide which cases it's going to hear. It's the only federal court that does that. And the implication of that control is that the cases it decides tend to be either difficult cases or really important cases, and often there's overlap between the two, so they're both. Most of the cases the court decides are cases in which the lower courts, either the intermediate federal courts of appeal or the state supreme courts, have come to different answers on the same legal question. And so the Supreme Court is the last court to decide those. And so you've got 2 courts coming out different ways. And in general, although not always, that means there are good arguments on both sides of the issue. So those make for hard cases. The other category of cases that the court decides are the really important cases, where it basically does the judicial equivalent of Truman's "the buck stops here" and says, this is important enough that we should be the ones to decide it. So often that's when a lower court has struck down a federal statute. That happened my term. There was a case in which a court had struck down the Defense of Marriage Act, or it'll be a really tricky subject area like the war on terror or a presidential election. So those cases tend to be very high stakes, and they get a lot of attention and a lot of good arguments on them. The last piece of basic information about the court that I wanted to put out is that the Supreme Court is obviously supreme in the sense that there's no other court that can review its decisions. Justice Jackson famously said, I'm going to read this because I always flip it, but that the court is final because it's not final, because it's infallible, but is infallible because it's final. If it gets something wrong, someone can't come along and fix it, for the most part. And so those decisions matter a lot. People pay a lot of attention to them. So that's the court. Now let me tell you a little bit about how the law clerks fit into that picture. There have been clerks at the court since the 1880s. The first law clerk was actually paid for by a justice, which as a clerk, I feel like is a good sign. It means that we must be doing something right and must be valuable because they'll pay for them out of their own pocket. But then eventually the other justices convinced Congress to pay for clerks, and it went from one clerk doing stenographic work, taking down shorthand, to 4 clerks for each of the justices doing a wider array of different tasks. And then currently there are 3 retired justices who are still living, and each of those justices also hires a clerk, and that clerk then serves in the chambers of one of the sitting justices. Clerking involves a ton of work. The year before me, a friend of mine was clerking, and his wife had a baby in May. May is sort of the busiest time at the court because you've got all these opinions that need to come out by the end of June. So he's at the hospital, and the nurse says, "Oh, how much time are you going to take off?" And he says, "Oh, well, I'm not going to go into work tomorrow." And she says, "Tomorrow's a Saturday." And he says, "Well, I'm not going to go in on Sunday either." And she says, "Well, how about Monday? Monday's Memorial Day. Surely you're not going in on Memorial Day." He says, "Oh, I'll be there on Monday." So the hours are long, and it's a tough year, but it's really an amazing job. It's a little, getting a clerkship is a little bit like winning the lottery, in one sense because it's this really valuable legal credential, but maybe more importantly, just because of how much luck goes into getting a clerkship. Chief Justice Rehnquist used to say that the top 5 graduates of the top 50 or so law schools in the country were all qualified to be Supreme Court clerks, much to the dismay of his clerks, who like to think of it as more selective. But I think that's probably about right. When I was clerking for the chief, one of the minor parts of our job was to sort through the hundreds of different applications that he got to try to identify the handful of the best applicants. And it was always a really difficult task and a humbling task because you look at all these people and you realize that there are just way more people who are qualified for the job than there are spots to fill. And so getting the job involves an awful lot of luck. I remember when I was clerking, one of the people who came in to interview he'd been the chief speechwriter to President Bush. And after President Bush left office, this guy had gone down to Crawford with the president and had written a book with the president. And so he comes in, and ostensibly the 4 of us clerks are interviewing him. But I remember just sort of sitting through this interview, and the whole time I'm thinking, you are so awesome. Like I'm so honored to get to meet you. So, all of that is to say, I feel very lucky to have been able to do it and really feel like it was luck. So I'm glad for that. But once you get the job, there are 3 or so major categories of work, and I'll sort of walk through what those different categories look like and tell you, I think you can see from that sort of what the work of the court looks like. The first big category of work is what's known as cert work, short for certiorari. I mentioned that the court gets to decide which cases it's going to decide, and the way it does that is through what are called writs of certiorari. So when a party loses in the lower court, they can ask the Supreme Court to grant a writ of certiorari, which will allow them, you see why I call it cert. So it'll allow them to appeal their case. The year I was there, people filed 8,000 cert petitions. Just as a point of comparison, when Justice Jackson was on the court, I think the number was something like 1,500. So the number has gone up pretty tremendously. And in the year I was there, the court agreed to decide fewer than 100. And in terms of cases that they actually decided after full briefing and oral argument, it was fewer than 80. So you're less than 1%. Your chances of getting onto the court's docket are pretty slim. But unfortunately, those 99% of cases don't weed themselves out. And so that's the first big task for law clerks, helping the justices figure out which cases are worth their time. 8 of the 9 justices, and by extension their clerks, do this through what's known as the cert pool. The 8 justices divide up the 8,000 or so petitions, and a clerk prepares a memo for each petition. So if you do the math, that works out to about 250 memos over the course of the year. And so you summarize the case and recommend whether the court should grant the case or deny it. And the numbers suggest that generally you recommend they deny the petition. And this cert work is generally the first work you end up doing as a clerk. The clerks, for the most part, start in July. So the court has already decided all their cases. They're not going to hear argument in other cases until October. And so you've got all this cert work. And you show up on your first day, and they give you your badge, and you go to your desk, and there's this giant stack of cert petitions. It's a pretty intimidating feeling, not least because you have to take that big stack of cert petitions and turn them into a memo that 8 justices of the Supreme Court are going to read. And you have no idea what you're doing, so it's, you feel a little nervous. And those memos continue over the course of the year. You start to feel a little more comfortable with them, and then more comfortable with them, and maybe a little too comfortable with them. But they keep coming, and it's a little like the opposite of Christmas morning. You walk into your office, and again, there's this pile of paper in your inbox. One of my co-clerks literally had a stack, this high, and you open them up and you look through them to figure out what they're about, and more importantly, how long it's going to take you to summarize them. Because as the term goes on, you get busier with other things, and you have less and less time during the day to actually work on these things. And so a complicated cert petition or 2 can mean you're there until 1 or 2 a.m. And maybe in part because you're there until 1 or 2 a.m., one of the other justices has a reputation for calling a clerk in another chambers if he thinks that the clerk maybe should have done a better job on the memo. So too many typos, or you're not describing something very well. And so I had heard about this when I started and sort of lived in fear of it. And one day, not too far into the term, fortunately it wasn't me, but one of my co-clerks gets a call, and the secretary says, "I have Justice so-and-so on the line for you." And my co-clerk was terrified. As he describes it, he needed a new pair of pants. So he picks up the phone, and fortunately, the justice just had a routine question. I don't think he realized that he was going to terrify this poor clerk. But so you have that fear living in the back of your mind throughout the course of the year. But you write these memos, and the justices look through them to figure out which cases they're interested in. And then every week or 2, they sit down and meet together to talk through the cases. There's no established law on how they decide that, but by tradition, it takes 4 votes to grant a case. So on a 9-member court, that means you can have a majority of the justices not want to hear the case, and yet the 4-justice minority can get it on there. I don't actually know what those meetings look like, though, because they protect their privacy very closely. And so the conference room in which they meet actually has a set of double doors through the main entrance, and they close both of those doors when they're meeting. And if someone wants to send something into the conference room, you knock on the outside door, and the junior justice, right now it's Justice Kagan, comes over and she opens the inside door and steps into this little airlock and closes it behind her and opens the next door and takes the message and then sort of repeats the process and goes back in. So one justice called the junior justice the highest paid doorman in the country. Justice Kagan is a good sport about it. The court is very much a seniority-based institution, so when they sit on the bench, they sit by order of seniority, and when they go around and talk in conference, they talk in order of seniority, and they also do committee assignments in order of seniority. And so Justice Kagan jokes that she's ended up on the cafeteria committee. The court has a cafeteria, and so she says she will be remembered as the frozen yogurt justice, because she was the first justice to bring a frozen yogurt machine into the courtroom and really bring the court into the 21st century. So the court votes on these cases in conference, they grant the case, and that's where the second big category of work begins, which is looking at the briefs. And again, you get a big stack of papers on your desk, this one with brightly colored briefs. I don't know if this is common in other courts, but the court color codes their briefs. So the first brief is blue, the second brief is, I blocked it from my memory, but the second brief is a different color. So you get this big multicolored stack of papers, with the arguments on both sides. And the lawyers at the court tend to be very good at what they do. So you read the first brief and you're sort of thumbing through it and you're thinking, yeah, of course, how could anything else be right? Then you get to the second brief and you say, whoa, what was I thinking? Of course, this other side is right. And then there's a reply brief, so you go back to the reply brief. And there's a lot of intellectual whiplash. And then, to make matters worse, it's not just the parties that file briefs. There are also what are known as amicus curiae briefs. It's Latin for friend of the court. The idea is that these outside organizations are doing the court a favor by submitting what they think the right answers to these legal questions should be. And the year I was there were 4 different cases in which there were more than 50 amicus briefs filed, and then 2 more cases in which there were 49 amicus briefs filed. The year before that, in the Obamacare case, there were like 136 different amicus briefs. So the sheer number of pages and the number of arguments can be pretty overwhelming. But I think it reflects the fact that, again, if the court messes it up, there's really nowhere else you can turn. So everyone wants to get their 2 cents in while they're deciding it. And again, the role of the clerks varies somewhat from one chambers to the next at this stage, but in sort of broad brushes, all of the justices are going to have their clerks read through the materials and then read through the decision below and do legal research of their own so that they can become familiar with the case. And the justice is going to read through the things as well, and then you can sit down or exchange memos about the arguments in the case and sort of summarizing what the parties are arguing and giving your take on what the right answer in the case should be. Now that I'm in private practice, I appreciate very much that experience, getting to see how a justice thinks through the issues and how they arrive at the conclusion that they eventually get to. You don't just see the opinions that they ultimately write out, but sort of how they're thinking through that. And so that was a really valuable part of the job. And also just the practice. It normally takes years and years before you can ever get a chance to argue a case before the court, and really only a small handful of people get to argue more than once before the court. But as a law clerk, you're working with a justice for an entire year on dozens of cases, going back and forth about these issues. And so you get to be a test subject for some of the questions that are eventually going to be used at oral argument. I remember at one argument last term, one of the justices had asked a pretty difficult question, and the attorney did a terrible job. He seemed to just not understand the basic premise of the question. The justice asked it 2 or 3 different ways, and eventually got frustrated and just gave up. And so afterwards, I was talking with the clerk for that justice who had worked on the case, and I said, can you believe how awful that attorney was? He just had no idea how to answer the question. And I loved her response. She said, are you kidding? That answer was great. He asked me the same questions, and I answered the first one, and then the ones that came after it were even worse. So it was a smart move, not letting him go down that path. So after they hold oral argument, the justices meet twice a week in conference to vote on the cases. And the chief would always call us into his office afterwards to tell us the results. And we would often try to guess what the results would be. There's sort of this is an aside, but there's a whole cottage industry that tries to guess how the cases are going to come out. I don't know how many of you are fantasy football fans, but there's a website called Fantasy SCOTUS. SCOTUS is the Supreme Court of the United States. And you can compete to predict which justice will vote which way in every case. It's pretty shocking, actually, how accurate the top people are. I think they get like 80% of the votes right or something, which is amazing. The 4 of us as clerks would try to guess, and I don't think we were anywhere near 80%. Sometimes we didn't even know what the chief was going to vote. So he would come back and he'd say, oh, they all agreed with me. And he'd sort of smile and we'd look at him and he'd say, what do you think, chief? Anyway, so they vote on the case, and then they divide up the opinions to assign them to different justices to write the opinions and the dissents. And one of the perks of being the Chief Justice, very few perks, but this is one of them, is that you're considered the most senior justice, even if you haven't been around as long as all the others. And so whenever you're in the majority, you get to assign the majority. Whenever you're in the dissent, you have the option to assign the dissent. And the chief is in the majority a lot. My term, I think he was in the majority 66 of the 78 cases. So because he gets to assign the opinions, he tends to write in interesting cases. And so it was great to work for someone who was deciding what he was going to write. Not to say that all the court's cases aren't interesting, but some of their interesting cases are more interesting than others. But so they assign the opinions, and then we get to the third category of work for clerks and for the court, which is helping the justices put together their opinions. And this was easily my favorite part of the job. Chief Justice Roberts is, I'm obviously biased, but I think this is objectively true, one of the best legal writers of his generation. Before he joined the court, or before he became a judge, he was a leading Supreme Court attorney and argued 39 cases before the court. Again, an aside, but I mentioned earlier that if the court screws something up, it's hard to fix that. One of the chief's early cases, he won 9-0, and he was pretty pleased about this. And I think less than 10 years later, the court revisited the issue and reversed itself 9-0, which you can see that both ways. But I think the best way to see that is that here's this issue that 9 justices eventually decided really obviously went the other way, but having the chief argue the case, they won. So the chief's a great writer. When you take writing classes in law school, you get excerpts from briefs that the chief wrote. And so it was really great to see how he would work through an issue that you had been thinking about for weeks, to get to sit down and talk with him about how to phrase that was really valuable. And because of confidentiality stuff, I can't talk about the specific process of writing it, but I think of working with him on these opinions. But I think the best way to illustrate it is actually a story that the chief tells about his time as a clerk working for Chief Justice Rehnquist. And so the chief had put together a draft, and he brings the draft in and shows the draft to Chief Justice Rehnquist, and I guess he was Justice Rehnquist at the time. And Justice Rehnquist says, I like the topic sentences of the paragraph, but it's a little too long. Why don't we cut out the rest of the stuff from the paragraphs? And the chief, thought that this stuff he had written was pretty good, and so he says, well, shouldn't we keep it? And Justice Rehnquist says, well, all right, keep the topic sentences and then put the rest down in footnotes. So she says, all right, that's a fair compromise. So he goes back and he writes out the opinion and puts the stuff down in footnotes, and he brings it back to Justice Rehnquist. And Justice Rehnquist looks at it and he says, okay, now take out the footnotes. So the big thing I learned from the chief was don't make things longer than they have to be. And I feel like maybe that's a good place to stop, fitting out to end on. But I'm happy to take questions if people have them.
Ben, why don't you talk about your first meeting with the Chief Justice?
Sure. So my first meeting with the Chief Justice was interviewing for a job with the chief. I had graduated from law school, and my wife and I took a trip out to California. We're standing, this isn't meeting the chief, this is learning I was going to meet the chief, but we're standing in a vineyard in California, relaxing after I had taken the bar exam. And I get a call, and it's the chief's secretary, and she says, Chief Justice Roberts would like you to come in for an interview. And so I was very excited. Fortunately, it was a month or two away, and so I didn't have to scrap our vacation to prepare for it. But so I eventually go down to D.C. To meet the chief, and it's a pretty intimidating experience. He's the Chief Justice of the United States. You've gone through 3 years of law school and read all these opinions from him and from the other justices. And you walk into this giant marble palace. So definitely an intimidating experience. But I talked with him for 20 minutes, maybe 30 minutes. And we were sitting on this couch that belonged to maybe John Adams or something. I forget. My father tells me John Adams died on it. I think maybe it wasn't John Adams. My father has sat on this couch as well. But anyway, someone very famous died on it. I should remember who it was because the chief told me in my interview that that's the couch that so-and-so died on. So none of these things put you terribly at ease. The chief is fantastic. He's very down to earth, and I got to know him better over the course of the year. I think we were one of the few chambers that got to have lunch with our justice on a pretty regular basis. So it was a lot of fun to get to talk with him about things other than cases. He's a big Notre Dame fan, so Notre Dame had the #1 football team in the country for most of that year, and so we got to talk to him about that a lot. It was a lot of fun.
Did you say that each Supreme Court justice has just one law clerk?
No, each justice has 4 law clerks, and then the retired justices each have 1 law clerk. And the law clerks to the retired justices help the retired justices out with speeches, and some of the retired justices actually sit on the courts of appeals, and so they help them out with that. But then they also work for one of the sitting justices.
So is there like about over 40 law clerks?
I think there are 39 of them.
39, oh yeah. So you get together socially when you're in Washington?
You do, and not so much. I haven't gotten together with them since I left the court. They got together on Wednesday night, but I missed it. But during the year, it's a lot of fun. The court really makes an effort to create opportunities for interaction that isn't just over cases. You're spending a year working on, in my term, gay marriage, affirmative action, the Voting Rights Act. And these are really controversial things that people feel passionately about. And so having the opportunity to get dinner and drink with people once a week really makes it easier to have those conversations. And so by tradition, every Thursday night, the clerks get together for a happy hour, and one of the chambers buys food and drinks for everyone, and you all get together. And then there's also there's a basketball court on the top floor. It's known as the highest court in the land. So the clerks get together to play basketball during the week. They always play in the evenings, though, because the highest court in the land is directly over the actual highest court in the land. So if you're bouncing a basketball up there, you can hear it. Hello. One of my favorite stories from the court is probably not true, so I left it out, but someone told it to me, maybe it's true. Back in the 70s or 80s, they're having an argument in the courtroom, and they hear thump, thump, thump from upstairs, and so I guess it would be Chief Justice Berger is pretty upset about this, and he writes out a note and hands it to one of the messengers who stand behind the bench, and the note says, "Tell whoever's playing basketball that he's fired." And so this messenger, takes the message and goes upstairs and walks out into the courtroom, or onto the basketball court, and discovers that Justice, I think it was Justice White, was there. And so apparently he was recused in the case or something, but he would play basketball all the time, and normally, when he would play basketball, the court wasn't sitting, because if the court was sitting, he wouldn't be playing basketball. But he's recused or something. So the messenger walks up and doesn't want to say, like, "You're fired." So he hands him this note, and the justice opens it up and says, "Tell him I have life tenure." As I say, I think that the likelihood that story is true is pretty slim.
Could the clerks sit in on the oral argument?
They can, and some of them do. You don't necessarily work on all of the cases when you're there for the term. So if you're working on a case, you're there for the oral argument. And then for the other cases, you can go if you want to, and there are seats to sit at. So I certainly got to go to a lot of really great arguments. And going to oral argument is a great experience. Unfortunately, it's become harder and harder. For the Defense of Marriage Act cases, when I was there, I think people lined up, camped out on the sidewalks outside the court for like 3 days before the argument to get a spot in line. And so as a clerk who had a reserved seat, I felt like I should go to all of these that I can. But when things get really busy, sometimes you don't get to go.
Ben, what kind of work schedule do the justices have?
They get to set their own hours, but it varies pretty significantly. Some of them work more from home. I mean, one of the nice things about the job is that you can really do it from anywhere. And some of them are morning people. Justice Ginsburg is famously a night owl, so she'll be at the court until 2 a.m. or something. So, it varies a lot, but it's a ton of work. And they're sort of always on from wherever they are. This isn't exactly your question, but one of the things that I didn't know when I started the clerkship is that the clerks, or the justices, are made aware of all of the executions that go on everywhere in the country, because there are often last-minute appeals in those cases. And so the court keeps track of these things. There's actually someone in not a law clerk, but someone in the clerk's office for the court, who's known as the death clerk, because he just keeps track of these things. And the court is really they're very organized about it and very professional about it. But because these things can be going on anytime during the year, often justices will be somewhere else, but are always in contact and able to find out what things are being filed and things like that.
Is there usually a year between the time of law school graduation and when you begin clerkship with the Supreme Court?
There is. It didn't used to be the case. So the first clerks were frequently right out of law school. Today, everyone who clerks at the court has clerked previously, and almost always it's with a Court of Appeals judge. So I clerked for Judge Sutton. One of my co-clerks had clerked for a district court judge and then a Court of Appeals judge, things like that. So there are a few different routes, but you always take some time off between.
But the fact that you clerked for the court in Ohio had no influence on you being hired by the Supreme Court because you hadn't. Did you have that position when you interviewed with the Chief Justice?
So by the time I interviewed with Chief Justice Roberts, I had already started the clerkship in Ohio. And Judge Sutton is great about telling the justices that he likes his clerks and they should hire them. So he said a lot.
When you mentioned how few cases get to the court, but when the case gets there, that there can be several amicus briefs. Are they in any way restricted? I mean, could a case get 40 or 50 amicus briefs, 500? I mean, once the case is there, does the court have to at least accept every amicus brief that comes across the threshold?
So my recollection is that if you file the brief on time, they're just filed as a course. You don't need to seek permission or anything. I think the most amicus briefs that have ever been filed in a case was the Affordable Care Act case, 136 of them. So 400 would be remarkable.
There'd be no limit. I mean, there's no.
Yeah, there's no limit. Now, I mean, the limit is that the briefs cost money to produce. You have to hire a lawyer to do it, and they can be pretty expensive to put together. So there's that limit.
How often do justices change their votes on particular cases?
I can't tell you. Which actually, I should say, one of the what's that? From 0 to 80. One of the great things about clerking, mixed blessing, but the court takes confidentiality really seriously. And so you really can't talk about your job at all. And so my wife was very respectful of that and really didn't ask me questions about anything. She wasn't trying to figure out the answers to cases in advance. But sometimes she would see a case in the news and she would say, oh, here's this case I saw, can you tell me about this case? And I mentioned that not all the clerks work on all of the cases, but maybe I should have, but I didn't want to just say, I don't know. So she would ask me and I'd say, I probably shouldn't say. So it's a nice out when you don't know the answer. But for your question, the answer is I can't tell you.
Ben, hey, thanks a lot for your comment. This is fascinating. I have two questions. How does the Warren County Courthouse room compare with the Supreme Court in terms of size, style, intimidation, but really more importantly, how did Robert Jackson decisions affect your day-to-day happenings?
So the courtroom is much more intimidating because I'm standing at the front instead of sitting on the side. And in terms of how Justice Jackson's opinions affected my day-to-day, it's not something I thought about every morning. I wasn't brushing my teeth thinking, what would Robert Jackson do? But he's obviously one of the most well-regarded and in many ways most influential justices. So, digression, but when I was going through the interview process, you're told a bunch of the questions that you might expect. And one of the common questions is, who's your favorite justice? And so Robert Jackson is one of the safe answers. And the reason for that is that he was a great justice, and he was also a really good writer. I mentioned the Chief's sort of focus on not saying more than you need to. I think that's something that Justice Jackson understood really well. And maybe in part from the fact that he was from this area and had worked on a lot of different kinds of cases and really understood how to communicate things clearly and simply to an audience that wasn't necessarily a legal audience. And so his opinions stand up to the test of time really well because they have law to them, but they also just have a lot of common sense. And so when you're deciding a case, it's really helpful to be able to look back at an older opinion that just makes a lot of sense and sort of says, here's how you should think about this question. Here are these 3 different categories that you can think about government power in, and here's how you decide which one it's going to be based on common sense. So I can't point to a specific decision that influenced the day-to-day, but he's certainly influential.
So this may fall in the category of unanswerable or not unanswerable. But can you talk a little bit about the role of the Solicitor General at the cert process, in the cert decision to grant cert?
So I'll talk about it in a way that it's not really based on personal experience or at least anything confidential. The Solicitor General is the government's attorney before the court. So Elena Kagan was Solicitor General before she joined the court. Chief Justice Roberts was the principal deputy assistant to the Solicitor General. And the Solicitor General's office is very careful about what cases they ask the court to decide. I can't think off the top of my head of how many times they ask the court to decide a case, but it's far less often than they could. So when there's a circuit split, and the government could seek cert, they don't always do so, because they want to wait until there's enough of a split that it really warrants the court's attention. And then the Solicitor General also has the resources of the United States government standing behind him. And so when he wants to figure out how important an issue is, he can call the Secretary of the Treasury and say, the Ninth Circuit just decided this case this way, how much is that going to cost the United States? And the Secretary of the Treasury can call back and say, $200 billion this year. And that's a pretty good line to be able to put in a cert petition, that they screwed up and it's going to cost us $200 billion. And then they're also sort of the ultimate repeat player. I mentioned that the chief argued 39 cases before the court. I think a big part of that, I don't know how many of those were while he was in the SG's office, but a lot of them were. And some of the people who work in the SG's office have been there for decades and have argued 150 cases or something. And so when you've argued that many cases, and frequently they're this the same person is arguing cases in the same subject area. So there's someone who handles the big criminal cases for the US government. And when you have that experience, you just have greater familiarity with the law and with how each justice will think about something. And so I think that probably gives you a better ability to tailor your petition to the kinds of things that will strike a chord with at least 4 justices.
Justice Jackson served as the chief prosecutor in the Nuremberg trials. And I read a biography on him in which he indicated that he was very concerned about his Supreme Court workload if he were in Nuremberg. How common has it been throughout the history of the U.S. Supreme Court that a sitting associate justice will take on a task like that while he is on the court?
I don't know the answer with confidence. I think the answer is it's basically unprecedented. Someone can tell me if I'm wrong about that. But normally the justices just work as a justice because that's plenty of work. The only other example of, it's not really similar, but example of a justice having another job. Marbury versus Madison is one of the most famous Supreme Court cases. It created judicial review. The idea that the court can declare an act of Congress unconstitutional. Maybe everyone knows this. I didn't know this before I went to law school. So Marbury versus Madison involves the president had appointed justices of the peace in the District of Columbia, but their commissions had never been delivered because the Secretary of State hadn't gotten them off his desk. And so the case goes up to the Supreme Court, and Chief Justice Marshall writes this opinion deciding the case. It turns out that the Secretary of State, who failed to deliver the commissions that sort of set the groundwork for the case, was Chief Justice Marshall, which today you would recuse yourself immediately, but at the time you hadn't. It's just different policies.
Do the law clerks separate on one particular case? Does one law clerk work on one case, or will each of you take a separate issue so that a number of you are working on the same case?
Probably shouldn't answer. I'm not. It's probably a harmless question to answer, but I'll stay clear of it.
Okay.
You probably visited the Jackson Center, and have you seen the wall where there's a list of books that was recommended that Robert H. Jackson's mentor, his former high school teacher, Mary Willard, recommended that he read?
I think I've
She
seen
was
it, but
hoping that he'd be president, you know.
I didn't. She must have been so disappointed.
But have you ever taken a look at that list of books that she recommended that he read?
I'm not sure if I've seen it, and I'm sure I haven't read all of them.
You should take a look at that.
Maybe I'll take one more question, or you can end there.
Do you clerk for just 1 year, and do you know that going in?
So the question was, were you fired? Yes, for the most part, you clerk for just 1 year. Sometimes when a new justice comes on the court, they'll ask someone who either had clerked for them on the Court of Appeals and then had gone on to clerk for the court to come back and clerk for them for a second year. So it's not unheard of to clerk for a second year. But the clerkships themselves are almost always just 1 year. All right, thank you all so much for coming.
We would like to give you a little light reading for the night. It won't take you long considering what you've just been through. But we do have an autographed biography written by Eugene Gerhardt, Robert H. Jackson, country lawyer, Supreme Court Justice, and America's advocate. And so we would like to give that to you as our thanks for coming.
Thank you very much.
Just 2 little footnotes on of the questions. And the first one has to do with about how many Supreme Court justices have taken a leave of absence from the court. And I don't have the slightest idea either if it's been more than Justice Jackson. But the first international prosecutor at the International Criminal Tribunal for Yugoslavia, the first international prosecutor since Nuremberg, Richard Goldstone, was on the Constitutional Court in South Africa when Nelson Mandela wanted Goldstone to become the prosecutor at Yugoslavia, their highest court, their constitutional court. And there was a huge uproar, particularly among other justices, that you just can't do this. And they pointed out the precedent set by Justice Jackson, who took a leave of absence from the United States Supreme Court to be the chief prosecutor at Nuremberg. And back here, over here, please keep an eye on the Jackson Center. Soon we hope to be opening an exhibit which is about the teachers' influence on their students, focusing around Mary Willard. And so we will hope to open that this spring at the Jackson Center. So please, we'll get word out, and please, we'd like everybody to come and see that. Gosh, another great birthday for Robert H. Jackson. We can't thank you all for coming. Can't thank you enough for coming. And again, we appreciate your support. It's because of you that the Robert H. Jackson can do the things that we do. We do have a few cookies and a drink on light refreshment on the way out if you're interested. But thank you for coming. Appreciate it.